Nehruji was a great leader, Sardar Patel was a great leader. What happened when 370 was being tabled? Your Lordships has seen, there was hardly any discussion. Because the government said that do not debate too much because advantage will be taken by the warring state across the border. Before UN, there was no debate. And in 1952, Mr. N.C. Chatterjee said that at that time you did not allow us to speak, saying that Pakistan will take advantage of it. But now in 52, then he put up questions. Of course, Nehruji answered it. These are only not critical of anything, that one has to place oneself in those times, and it is difficult for us to go on a flashback in these cases. They're difficult times. So he answered it then, but those questions were not put. So one can't put reliance on the speech of Mr. Anger or this or that speech of Mr. Sheikh Abdullah. They were divergent interest also, clashing interest also at that time in play. It doesn't detract from the stature of any of the political leaders. Sheikh Abdullah was a great personality, political leader. Nehruji was a great leader. Sardar Patel was a great leader. But what of that? Churchill was a very great leader. But after the Atlantic Charter was hashed out on the seas with President Roosevelt, when he was posed with the question, what about India? He said, this charter doesn't apply to the India. They are colonies. It is only meant for France and Poland, etc. in Europe, which lost freedom and their territory to Hitler. So they're all great leaders, but they grapple with their situation in the interest of their nation. And in this case, when 370 was being drafted, please bear this in mind, my lords, these circumstances which were prevailing then. And one more very vital circumstance. We have been hearing, lords, and sometimes I've read through the Constitutional Assembly debates also, many books also. They all said war is going on between India and Pakistan. What was that war, my lords? Somehow, my lord, we are still, the lips are pursed and we don't want to speak about the truth. Who was the Supreme Commander, my lord, of the Armed Forces? Auchinleck. All the three generals of India were British. All the three generals of Pakistan were British. What was this war, my lords? Churchill had, my lord, designed there itself that India has to be partitioned. Geopolitics. This war was a British war. They created it on both sides. The raiders came from where? Northwest Frontier Province. After 2 terms, Mr. Cunningham, who had been governor in Northwest Frontier Province, he was brought back in July, just before the elections, referendum. The raiders were trained, sent on trucks with weapons of army. Pakistan army had just been split from India. And the biggest, starkest example is, Lord, who was fighting, Lord? What is this POK today? 2/3 of POK is Gilgit-Baltistan. And who fought the war there, Lord? Not the raiders. It was Major Brown, who was the regent there. He was posted again in July, just before that, by Cunningham. And this is a book, Lord, Mutiny. He killed all the forces of Maharaja. Ansar Ahmad was posted there, Lord, and he was arrested. And he, in 4 days, Lord, he hung the flag of Pakistan and he had handed over to Cunningham. He sent some Mr. Alam from Pakistan army and he took over Gilgit-Baltistan. Where is the war with Pakistan? It is British. But if we close our eyes to all these, then it is the raiders fighting across the world. Raiders could not by themselves come up to Srinagar. The war had reached almost this Kardu and Kargil and to that closeness to Tibet, Leh. So it was a war of a different kind, but nobody could say it because Mountbatten was there, as the Governor General. Again, must have the leaders, our leaders must maybe having some reason that even though Jinnah said, I will not accept any British Governor General, but the party said, no, we are ready to accept Governor, you continue with Indian Governor General. So what is this war? Governor General, and not only this, when the war began, they constituted a defense committee of the cabinet. And Mountbatten was made the chairman of that. So it's an excellent situation. Mountbatten is the chairman of defense committee. Auchinleck is the supreme commander of forces. All generals are British, and one Britisher is mutinying, and when he returns to England, he is given the medal of the British Empire. So that's not the position of the war. So when you read the Constitution and 370, please bear in mind these things, in what circumstances our leaders were moving through. And when we were about to push them back and recover the territory, they deliberately stopped the war at a point of time and got the reference to the United Nations. Because if you had gone up to Mirpur and behind, then that connection would have been off with Gilgit-Baltistan. Now, these are hard facts, nobody can dispute it. It is in these circumstances, and what was United Nations? The same very power which for geopolitical reasons, the US and UK, which wanted to partition India, they were the arbiters. Fortunately for us, Pakistan refused to vacate POK. So that resolution is dead. There's no need talking about United Nations, but at that time, look at the enormity of the situation in which 370 has been. We can't interpret it, therefore, with a tool of interpretative toolbox. Maxwell cannot answer this. Bennion cannot answer this. Craze cannot answer all this. None of the judgments so far which have been delivered in this court are helpful at all, to reach a conclusion, except Sampath Prakash, which dealt with to some extent with the situation after the expiry of the dissolution of the Constituent Assembly of Kashmir. That and that alone. The rest are all in different contexts, principles we can help, take help of. But this situation, if lost sight of, creates problems, at both ends. You accept their contention, then this becomes permanent. There is a proviso under 368, we can't amend it. Go by the route of 370, and 370 is permanent, and therefore, we are left at the mercy of the local vested interest, which does not always coincide with people's interest there. So you, therefore, look at the consequences of both sides. On one side, if you accept our submission, the right of the people of Jammu and Kashmir gets expanded. And they don't suffer, Right to property is a matter of the rich and the neo-rich, The poor people, they're hardly 19(1)(f), they're hardly concerned. But even those smaller people who have small houses, etc., so certainly it has meaning. But then 300A is there, which virtually subsumes, now it's a human right under the Constitution. So nothing is lost, not even 19(1)(f). Nobody can confiscate because of 300A. So 31 and may not be exactly at par with 31, but substantially it is there. So nothing is lost. They are put at par. The basic structure of federalism is protected. I don't know how the submissions were made that federalism is affected, to keep it in mind. This is federalizing at par.
According to them, federalism is affected because you reduce the level of a state to a union territory.
Unless you accept asymmetry is basic structure, then they are affected. Asymmetry is never a basic structure. They are for special conditions. Asymmetrical dealing with a state.
Mr. Dwivedi, this matter apart, the existence of a state is a very vital element in the federal.
I'm not on the state.
The existence of a state, the continued existence of states is integral to federalism in India.
Well, sir, I will humbly request your lordships, I'm dealing with CO 273. 272, which deals with 356, that has been answered by the Solicitor General, or whatever, your lordship will consider that. Supposing, my lords, for a moment, for my submission, please assume, my lord, that 272 and the act is not there. Because it's my case, what I am conversing for is, irrespective of 356 invocation and Article 3 invocation, 273 is sustainable on the anvil of 370 main part itself. It says that Parliament has recommended and we are passing this. Obtaining the recommendation of so far as involvement of Parliament is concerned, it comes in two ways. One is
just to sort of break your leg a bit, you spoke of there were 5 constituent powers.
The fifth one I have mentioned.
We got third. We have the original constituent power by which the constitution was framed. Second was ancillary constituent power. The third was amendatory constituent power. That's the third.
The fourth, my lord, is like the provisions like Article 3 and 4, where amendment of schedules relating to states and their structure, etc., Article 3 and 4, they can be altered. And by a law of Parliament, and it is provided that they are not to be treated as amendment under Article 368.
Then can that be treated as a constituent power at all if it's not an amendment to the Constitution?
No, so they are amending the schedule to the Constitution. Their levels are different.
But the Constitution tells us that it's not really an amendatory power.
So therefore, I'm saying that these are the 5 different ways in which the power has been conferred. This is another way where they say that you can make a change in the Constitution. Because my postulate is that every change in the Constitution itself, if brought about, is a constituent power.
All right. That's the fourth.
And the fifth is, my lords, Article 1C, where this court has held that if you acquire some other territory, then it says I'm sorry, Article 2, my lord.
2, not 2.
Yes. 2. I'm sorry, Article 2.
Parliament may by law.
Yes. Admit new states on such terms and conditions that things fit. Again, my lord. Very wide. So while admitting, my lord, A, B, or C country, let's say, my lord, some bordering city of China, my lord. They are very interested in naming our cities, my lord. If that is admitted, just aside, my lord, so if it is admitted, my lord, then the terms and conditions can be fixed.
Therefore, your argument is that the exercise of the power under Article 370(3) is a constituent power exercised by the President.
So your lordship's judicial review has to be on that basis. And it's when your lordships expound 370, it has to be with that in mind, my lord.
So the level of deference would be much higher than even the level of deference to an ordinary piece of
legislation. Executive order, then Wednesday principles and all those things will come in. Whether your lordships will bear judicial restraint, that's the other side of it.
That's the exercise.
Yes. If it is legislative, as the lordships put Article 14, how it will come is whether it will succeed or not is quite another thing, but amenable is the lordships. But if it is constituent power, which is continuing and is part of the constitution making, part of federalizing, this is part of constitution making, part of federalizing Jammu and Kashmir at par with other states. I will read two state policies, one placed before the Constituent Assembly by the State Department and the other the speech of Sardar Patel, where they spelled out the policy. This was a departure from that policy. And departures are not permanent. Can never be permanent. The policy is states, that is the Indian states and the British provinces under the Government of India Act should be brought at par, at equal level. That was the policy. And placed in October and November 49, just before the adoption of 370. So 370 was a departure being made because of circumstances, political pulls and pressures and so, and the circumstances which I narrated. So therefore, you have to therefore consider this as a continuing process which was meant to be terminated, and 75 years is a pretty long time for federalizing Jammu Kashmir at par with other states. That means that the power was rightly vested in the president and was properly exercised by them. It was not that in 1957, one may ask not that if my contention is accepted, then immediately after dissolution of JKCA, the president could have terminated. Yes, he could. It's a high political policy. It's an act of state. There were some states where forces were sent. That can't be questioned, that how Hyderabad was brought, how Junagadh was brought in, how a referendum was done. All those things are in the past and they were act of state. Mr. Sibal said that had there been another route, act of...
An act of state is executive, right?
So, executive, nothing prevents the Constituent Assembly from putting a power in the Constitution itself. So that, it is, what was expected was that the Constituent Assembly, when it sits, it might well take a decision that please align us at par. The recommendation, part of it, the proviso, was merely to enable the JKCA to look at the advantages of the federation.
Deveri, what was pointed out by the other side was,
yes,
when you frame the constitution, when you enact the constitution, then you're probably exercising constituent power. What happens thereafter will be either in the realm of legislative power or the executive power. If we go by this.
So that's not right, my lords. And that's my contention. They are not correct in that. It's not always, then 368 law is not purely legislative and executive.
Now, you are equating 368 also to constituent power. Yes, by saying that it is also a constituent power. That way it is. Whenever you will be amending the constitution, you will be making changes in the constitution. But that exercise cannot be equated with the constituent power for the simple reason. Constituent power has the power to go from a scratch, from 0 point.
Not necessary, Lords. A mandatory power is constituent.
Yes, a mandatory power is certainly
so this
there.
is a mandatory, Lords. You can much wider.
No, the question is not that. The question is, can the mandatory power under 368 be taken to the level of constituent power as to go?
I never said that, Lords.
You're not saying that.
No.
So what you are saying, therefore, they're really speaking, there's jurisprudentially there won't be any difference.
There would be, Lords. The nature of power is completely different. That has to be realized. an executive power of the president is, for example, he recommends, my lord, financial bill should be passed. That's a different kind of power.
That's correct.
So the president has a whole lot of role to play under the constitution. All roles are not at par. For high policy reason, this was given, my lord. No, but this proviso to 368 is because the government, my lord, of India did not want, my lord, to go through the route of 368 every now and then. So if you want to, my lord, do away with 370, go to 368, then 2/3 majority, and then you maybe somebody will say state is affected, so ratification by majority of states. So an easier, my lord, because the policy was to put at par. Therefore, my lord, it was, since the policy is given, alignment is the question. Alignment may take such time, my lord, as the circumstances permit. Nobody can predict how much time it will take. So, and this was provided here. Keep also one more aspect in mind, my lords. The framers of the constitution knew that a president of India is a continuing office. It will not lapse after any point of time. Whether it is part of basic structure or not. But even if it is not, nobody expected that the President of India office, high office in which the executive power vests, will vanish. So it was a continuing power. They also knew that Jammu Kashmir Constituent Assembly is an ephemeral institution. So they had two institutions, one permanent, one ephemeral. They are being brought into a relationship in 373 with a notwithstanding. So now not an ephemeral expiry of an ephemeral institution impacts the permanent institution of the president. That can never happen, my lords. If that were the intention, what was so difficult in 370 to add a few words that with the expiry, my lord, of the JKCA, if I may use this short JK Constituent Assembly, then, my lord, the main power will also lapse. The framers are very well aware of cessation of certain exercise of power after certain period. Be it 356, 352, ordinance making power, place in 6 months. If you don't place, it will lapse. My lords, have dealt with, my lord, in Krishna Kumar Singh. Even 249. So there are so many, my lords, situations. They are aware. They are casting the languages of different provisions with this expression that it will cease for different reasons in different cases. Why is it that they are refraining here? Certainly, my lords, it could not have been in their mind, my lord, that this will remain for all times to come, my lord, till eternity, my lord. The relationship of Jammu and Kashmir, my lord, state as a federal unit with India will remain different for no reason whatsoever. And as my lords had put a query to them, if I may just adopt that. Supposing, my lords, through the route of with concurrence and consultation, well, everything has been adopted. So why do we want to keep this relic? For sentiments, my lords. So it has to go someday, my lord, somewhere. And what is it that remains today, my lord? It may not be a shell, but close to a shell. And my learned friend Zafar Shah said, my lord, we have sentiments. Yes, we understand that. If I live for too long, my lord, with a particular provision, well, there will be sentiments, my lord. No difficulty, my lord. We appreciate that, we honor that, we respect that sentiment. But equally, just a human life, my lord, the time comes when you have to bury it. We have emotions, we have sentiments, but we have to bury, my lord. We have to cremate. So that's what, my lord, is in mind, my lord. That please, therefore, my lord, your lordships are acting as a part of a constitution making process. This adjudication is not apart from, my lord, completely disjointed and disregarding that process. Host of other things your lordships have already noted, this temporary here, temporary that. Right? They say marginal note, somebody says temporary is only object, not the time period. This is not the way the lordships in Bombay have construed. Sometimes the lordships take help of the marginal note, sometimes the lordship doesn't. But here, the conglomeration of 370 along with all other provisions originally there. I'm excluding the special provisions. All the provisions were temporary. Somewhere time period was fixed, somewhere time is not fixed. But all intended to lapse. There are temporary provisions elsewhere also, like 306. So they are meant to go. Don't hang on it. Nobody hangs on a body which is just a shell. It causes only those some. I can understand people with good intention. They respect that emotion. There will be a host of other people who will take advantage of that, and in Kashmir they have taken it. There have been time and time again calls for plebiscites, independence. In fact, in 1964, just before his death, the Prime Minister Nehru, he had sent Sheikh Abdullah, brought him back as Chief Minister, sent him to Pakistan with a message that you be a bridge between India and Pakistan. And he was going to POK when Nehruji died. Unfortunately, he expired. So I had to return from here. But I mean, that emotion which is created at that time in 52, 53, why will a person be kept in a jail for 18 years long? He suffered, yes. He contributed to India, but he stood also with his own emotions. We all respect all those emotions. Nobody condemns any emotion in human life, in a nation's life, in a state's life. These emotions arise and die. So, for emotional reason, 370, I think it's time to bury, and that's what was intended when the framers brought in 370, and that's how it is. 373, therefore, not CO has to be upheld. Now look at it once more. We are like 7 men and the blind men and the elephant. So we are all putting our perspectives before lordships, lordships. We will kindly receive that and find out what is the whole, integrated whole.
Seven this side.